good morning and good afternoon for people in China, in Beijing or other places. And welcome Yang Li, the Executive Director of Institute for China-Europe Studies based in Brussels. So today we are actually having a dialogue among European and Chinese scholars about international law, particularly the law of the sea. It is generally observed that the rules-based international order, or maybe in Chinese terms, that the international order based on international law is under stress. The return of great power competition and the withdrawal of the United States from the multilateral commitments create a lot of uncertainties to world affairs. Many pressing global challenges or global issues are more or less sidelined. So the oceans are actually, many of these issues come together. The oceans are becoming a more heavily contested area, both in geopolitical and geoeconomic terms. And they also become a focal point for plenty of global challenges and a new frontier for scientific and technological advancements and a testing ground for the evolution of international rulemaking. So right now we have a whole set of rules governing the oceans, mainly embodied in the 1982 United Nations Convention on the Law of the Sea, apart from other sources. Now it has been over 4 decades since the convention was adopted. And today's international situation is very different from the time when the convention was created. So as a result, I think the convention and the entire legal regime of ocean governance is facing a range of new challenges. In many of today's international and regional hotspots, either real or potential, there is always a maritime dimension. For example, the conflict in the Middle East has brought renewed attention to the right of transit passage through the straits used for international navigation. Both Europe and China are confronted with threats, challenges, or troubles from the seas, although they might be different in nature and intensity. At the same time, the developments in deep sea mining highlight the complex dynamics among political, economic, and even strategic issues, such as access to critical raw materials, resilience of supply chains, global competition for ocean resources, green transition, and of course, protection and preservation of the marine environment. So against this background, it is essential to review the implementation and the further development of international law of the sea. I read that I think CIMA, China's Institute for Marine Affairs, released an assessment report just a few days ago. So that actually everybody is asking the question that, is the convention still effective? Can the convention continue to meet the objectives it was designed to achieve, such as maintenance of peace and stability, facilitating development and prosperity, and conservation of marine environment and biological ecosystems, ensuring an equitable balance of interests among different players, including coastal states, eurozone states, landlocked states, developed countries, or less developed countries, sustainable and predictable exploitation of marine resources, and of course, reliable conservation of marine environment. And what role could Europe and China play in upholding the international legal order on ocean governance while managing differences between the two sides, especially, as I said earlier, when the role of the United States is becoming less clear? So today we have a distinguished panel of speakers. First, we have Eva Pejsova, Japan Chair at the Center for Security, Diplomacy and Strategy at Free University of Brussels, VUB, and Associate Fellow at the French Fondation pour la Recherche Stratégique. Her research focuses on security issues within Indo-Pacific region related to maritime security, sovereignty disputes, regional cooperative mechanism, and ocean governance. Then we have Dr. Zhang Xinjun, Professor of Public International Law at Tsinghua University, Beijing. His research interests include the law of the sea, international environmental law, non-proliferation law and the law of treaties. Last but not least, but I'm not sure whether he's here with us right now.
Yes, I think Professor Rubin is with us now. He's online.
Okay, thank you. Welcome.
Good
So
morning. Good morning. Thank you so
yeah.
much.
So we have Dr. Volker Rubin, Professor of International Law and Dean of Law School at Durham University. His research is in the areas of international law and EU law, with a focus on the law and policy of energy, as well as comparative public law. So welcome all of you. So in the following, I would ask each speaker to make initial remarks for about 8 minutes. After that, I will hold a open discussion among the speakers, among the panelists, followed by about 20 minutes Q&A. So in order for the speakers to answer as many questions as possible during a limited time frame, so we encourage every audience to leave your questions anytime during the discussion to the chat box below. Thank you. And also, just for the order of the meeting, please keep yourself muted unless you are given the floor. Okay, so that I will start with my questions to the speakers. I think, as I mentioned just now, I think the speakers are invited to talk about the following topics. How well is the United Nations Convention on the Law of the Sea being implemented? What opportunities and challenges are raised for its future development by current happenings and hotspots? If there are any deficiencies, what are they? And what role could Europe and China play as the two major actors in this field? Are there more divergences or more convergences between Europe and China? And how to realize the potential while manage the difference? So I will start with Eva, and then followed by Xinjun, and then Volker. So Eva, you have the floor, please.
Well, thank you very much, Angli. Apologize to everyone for my broken voice. I caught cold in the middle of a heat wave, but I hope you can hear me fine. Now, it's really a pleasure to be here. It's always a pleasure to be part of an interesting discussion, and these are certainly most important topics and ones that, as you said, Europe and China can actually or have to think on how to cooperate closer together. Now, you have given us a very intriguing set of questions ahead of this. Anything from transit passage to the Strait of Hormuz to indeed the kind of future of maritime rules-based order and ocean governance. The one thing that all these topics have in common, and as you already pointed out in the introduction, is that they all boil down to geopolitics. It is really the geopolitical tensions and rivalries that have been kidnapping those issues that kind of in principle were considered a matter of common good or be treated more in a more neutral manner. So I'll try to answer your questions in roughly kind of going through three parts, starting with the Strait of Hormuz, then order in more general terms, and finish with some of the next frontiers of ocean governance. And I think the recent crisis in the Strait of Hormuz is really a perfect example where we see this growing gap between theory or international law and the practice. Now, the question you have asked is whether the transit passage in straits used for international navigation constitute customary international rule, and how the transit passage should be interpreted or applied. Now, according to law, I think it's very clear. Yes, it is customary law. It is. UNCLOS is very clear on the transit passage, Article 38. On the right of unimpeded transit passage, Article 44, on the duties of bordering states, meaning that they should not hamper in any way the passage, and of course notify of all possible dangers. Now, it is a fact, and it's in principle applied, of course, in peacetime. Now, in wartime, there's an additional legal layer here with the law of armed conflicts at sea, which still, of course, should act according to certain rules and principles. Now, We do recognize that belligerents may, interdict passage or create some sort of limited blockade or with mines, etc. But of course, it needs to be justified, it needs to be targeted, and it should not impact the neutral shipping. Now, in reality, we have seen that this is very hardly the case. The secondary impact on the global economy, on oil prices, on shipping, on fertilizers, and the spillover effects it had on the global economy, on food security, on supply chains, or humanitarian effects that it had, go well beyond this. So what the lesson that we've learned is that, navigation in choke points is not really just a legal or a military matter. It is really a major systemic economic vulnerability and should be treated as such. So there's no such thing as a partial blockade or soft blockade or limited blockade. Basically, all sort of disruption has a much broader effect. And none of it can be actually treated in isolation. The problem of accountability is something that will kind of run across all the maritime security debates, is that we, of course, don't have ways or not enough strong tools to actually enforce or hold the culprits accountable. The cases of unlawful blockades have been numerous in just recent years. We're talking Gaza, we're talking Yemen. It's very difficult to prove and even harder to punish. So it brings me to the question of maritime order more general. And one of your questions was, what are really the main contending points? And if I had to tell just one, it is, to me at least, this basic contention between sovereignty on the one side and openness, right? So how much control the coastal states may exert on the one side, and how much freedom can the user states enjoy on the other. And there's no better example than the South China Sea, or basically all that water space laying within the first island chain surrounding China. So East China Sea, Taiwan Strait, and the South China Sea, where we see China basically considering these waters as sovereign waters, as an integral part of its national territory, which according to UNCLOS it is not. And of course, the user states, including the Europeans, but pretty much everyone else, consider it as international waters, and they enjoy the freedom of navigation, innocent passage, and all the regulations that come with it. Now, the problem of this securitization is that EEZ becomes de facto a battleground. So what it used to be a zone where you could exert a number of freedoms with certain caveats, basically becomes a sort of a 200 nautical mile buffer zone or security buffer, which of course is complicating things. And instead of actually trying to securitize the space, we should focus on securitizing the conduct. So the specific acts of sabotage or spoofing or some sort of illegal operation, that's fine, but not to securitize the geographical space. That would be one kind of advice. What we are seeing, I mean, you asked if, UNCLOS is becoming more fragmented. I think it's more, the future will be more about contested interpretations of the rules-based order. And of course, on the one hand, we will see more lawfare, which we already see in the case of China, and on the other hand, more protest practices of the others, all trying basically to find to prove their point. Now, does it call for, or does it mean that UNCLOS is somehow obsolete? To me, the answer is clearly no. I don't think we should touch UNCLOS. That's really the main reference. That's the constitution for the oceans. It's an anchor. The problem is compliance. So it's not the law that should adopt. It should be the states who should comply more or better to actually make the system more effective. And in reality, let's face it, the vast majority of states actually respect and abide by UNCLOS. Those who do not are more outliers, or at least less numerous. So yes, UNCLOS is not perfect. I mean, it was written in 1982, at a time where a lot of the issues that are emerging now could not have been anticipated. And that's why I presume, of course, seabed mining is included in this discussion, or, the loss of biodiversity beyond national jurisdiction was not anticipated in 1982, same as climate-driven sea level rise that also has an impact on boundaries, etc., etc. So what we are seeing now with the BBNG, for instance, is that we will have more supplementary agreements. That doesn't mean that it's becoming more fragmented, but actually more dense. So UNCLOS remains, or at least how I see it, that the anchor, the basis, the constitution, and on top of it, you will have more specific, more technical, kind of issue-specific agreements and treaties that will deal with the topics that are not covered by UNCLOS. So it's a sort of a layered form of governance, which brings me to my last point about governance. And here, the two cases, the BBNG and the deep sea mining, are fascinating to me. And I'm looking forward to hearing from colleagues on this, because clearly we are at the very beginning. The negotiation itself was the easy part. Now, the most important, and I'm talking about the BBNG here, is yet to come. We still need to agree on the institutional design. So make sure that the scientific body is independent, agree on the clearinghouse mechanism, on the financing, etc. The Article 5 is problematic to me, of course, the fact that basically anyone can veto the protection at any time when not convenient. Well, that's usually we often see that in international treaties, because it managed to get the countries on board, but of course it's deeply problematic, because the marine protected areas will only work if the regional fisheries management organizations, the IMO and the ISA, cooperate. The universal application, of course, we still have countries that have not signed the BBNG, and also thinking about the benefit sharing. If the whole purpose was to kind of get to a more equality or equal repartition of the benefits, then we need to give a little bit more thoughts on the benefit sharing. The deep sea mining, to me, is quite worrying, because it seems that we're de facto in a stalemate. So the ISA, as I understand it, has already been working on the mining code since over a decade. But while we still don't have a binding treaty, of course, the United States and others are advancing. So either we negotiate something quickly, but it may be too quick and not sufficient, or we wait longer while basically there's unilateral attempts and countries doing whatever they want, which seems to be the way things are going these days. Now, I understand China is one of the countries that has been pushing for a quick negotiation of the mining code, but really it needs to be. I think there's an opportunity for Europe and China, and this will also lead me to my conclusions about the opportunities. It should be a strong one, and of course, it's not an easy task. Now, Europe is, and I'm talking for the EU as such, EU actually negotiated the BBNG collectively, and it is acting quite collectively when it comes to ocean governance. Since 2016, it's been the promoter of the international ocean governance under Sustainable Development Goal 14. And it is kind of the natural anchor of those multilateral initiatives. It funds the capacity building in a pillar of the BBNG, and it's very much involved. But China is pivotal, of course, also in the deep sea mining part, right? Most of the current contracts under ISA are Chinese. It's been vocal, and here we agree. We've been very critical of the US unilateralism here. So it is really a time where we can join forces in trying to demonstrate our collective strength, if you want, in within the UN, within the agreed kind of borders and frameworks, and try to also prove that we can make it by delivering. And here it could be something very simple, or it's just try to deliver one functioning high seas marine protected area. Or try to present one environmentally sound, credible mining code process as an initiative. I think would be a very useful, tangible outcome if I kind of would end on something rather concrete. And I'll stop here.
Thank you. Thank you for a very comprehensive coverage of all the points that would be very interesting. And also, I noticed that you talked about systemic vulnerability, which is, I think, is together with the growing geopolitical tensions, might add pressures toward the current international ocean governance legal regime, because this kind of vulnerability is very easy to lead to secretization of everything. So that, and you also mentioned about desecretization of these issues. So how to make it more like, how to say, not that people will feel less, vulnerable, so that they could have more greater space for cooperation and pushing forward the legal regime. We will come back to those issues later when we have follow-up questions. Now I will give the floor to Dr. Zhang Xinjun. So please, you have the floor.
Thank you, Yang Li, and thank you to ICES for organizing this timing discussion. I will focus on 3 examples: the Strait of Hormuz, the recent Baltic Sea submarine cable incidents, and the border development of the law of the sea through the BBNJ Agreement and adversarial opinions. My main point is that the law of the sea is not only being applied today, it is also being tested and developed under pressure. Not pleasure, pressure. The question is how to develop it without losing the balance built into the UNCLOS. So let me start with the Strait of Hormuz. Hormuz lies between Iran and Oman at the mouth of the Persian Gulf. The narrowest point is often described as about 21 nautical miles. But its importance does not come from geography alone. It comes indeed from the fact that it is the only maritime outlet of the Persian Gulf, and the Gulf contains several major oil and gas producing states. So if the same strait were located outside this energy geography, Iran's legal position might not attract the same global attention. Hormuz is therefore an oil choke point, but also a legal choke point. Under UNCLOS, Hormuz appears to fall naturally within Part 3 on straits used for international navigation. If Article 37, 38 apply, the regime of transit passage, which means a continuous and expeditious navigation and overflight, should not be subject to suspension by coastal states. The difficulty is that Iran has signed but not yet ratified UNCLOS and has long insisted the view that the transit passage in Part 3 has never been customary international law. Iran's legislation and practice tend to treat the Iranian, at least the Iranian side of Hormuz as territorial sea, governed by the regime of innocent passage, not transit passage. The position would allow restrictions inconsistent with the full transit passage regime, including restriction on overflight, requirement for submarine to surface, and suspension on security grounds. But Iran's non-ratification does not mean that it may simply close the strait. The higher and, in my view, the contested question is whether the full Article 38 regime binds Iran as a customer international law. I have, a question mark on that one. Maybe you have different ideas. We may discuss it. The lower but firmer baseline is the general international law still protects passage through international strait. Let's then go back to the 1940s. The Corfu Channel case remains important here. It tells us that in a strait used for international navigation, connecting two parts of the high seas, the coastal states may not, in time of peace, prohibit innocent passage. So even if one does not accept the full transit passage argument, Iran still cannot, in time of peace, suspend innocent passage of vessels through the strait. I will leave the most difficult issue on the law applied in straits in time of war, time of armed conflict and discussion, maybe. So for me, Hormuz suggests that we may need to think not only in terms of rule application, but also in terms, in my view, institutional design. Iran may be seeking, explicitly or implicitly, a special Hormuz arrangement, one that recognizes security concerns while preserving international navigation and energy flows. Here, I think maybe the Turkish Straits and Montreux Convention offer a kind of analogy, although it cannot be a model to be copied. But the analogy reminds us that some strategic straits may require special arrangements combining passage, security, crisis communication, and regional stability. China and Europe may share interests here, keeping the strait open, but in the meantime, avoid escalation, stabilize energy transport, and prevent unilateral military enforcement from becoming the normal method of ocean governance. Differences may remain over coastal states' security and U.S.-led security structures, but cooperation is possible around the de-escalation, notification, maritime safety, and a regional mechanism involving probably Iran, Oman, and GCC states, major user states, and relevant international organizations. Now, the second example is the Baltic Sea submarine cable instance. This instance raises a different problem. Hormuz concerns the passage through a strait. The Baltic cases concern foreign vessels in the exclusive economic zone and damage to submarine communication cables. The recent cases include New Polar Bear, E.3, Eagle S, and Virgin. They are factually different, but legally they expose the same difficulty. What can a coastal state do in its EEZ when a foreign vessel is suspected to damaging critical underwater infrastructure? UNCLOS gives coastal states important rights in EEZ, but those rights are specific. They concern natural resources, marine scientific research, protection of the marine environment, and artificial islands, installations, and structures. Ordinary submarine communication cables do not neatly fit into this category. They are not living resources. They usually do not create serious pollution risk, maybe with the exception of pipelines. And they are not normally installations over which the coastal states has, the so-called Article 60 jurisdiction on the artificial islands and installations. This means that the direct legal basis for coastal states' enforcement against a foreign vessel in the VEZ is limited. Here, Article 113 is important, but it must be read carefully. It requires states to adopt laws and exercise jurisdiction over the breaking or injury of submarine cables. But it is mainly directed at flag state and the states of nationality. It does not clearly give the coastal states a general power to board, arrest, bring into port, and prosecute any foreign vessel suspected of damaging a cable in its EEZ. So the Baltic practice reflects this uncertainty. Some responses relied on flag state cooperation. Others, such as EGOSAS, involved stronger coastal states action. Yet, subsequent proceedings also show the legal risk. Authorities may still face the absence of sufficient. I'm sorry. Wow. I'm sorry. This my computer is going is going to be dead. I'm sorry. I need to get a outlet here.
Okay, so how long will it take, or should we move
One
on?
minute. Sorry. 1 minute. Sorry.
Okay,
Sorry.
no
I will
problem.
just. I hope the cable is not made in China. Sorry, yeah. Well, where should I? Yeah. So all these instances indicate a fundamental problem about the freedom of navigation in the EEZ. In recent case law, freedom of navigation has been sometimes moved beyond the narrow idea of physical movement of ships. It has been used structurally, together with exclusive flag state jurisdiction, to resist coastal states' creeping jurisdiction. Cases such as North Star, Eric, Laxey, Arctic Sunrise, and Nicaragua versus Colombia, which is done by the ICJ, I think, in 2022, actually show this broader tendency. But we should be cautious. If every activity not expressly reserved to the coastal states is automatically absorbed into an abstract freedom of navigation, then UNCLOS Article 59 will lose much of its function. Article 59 recognizes that the allocation of rights in the EEZ may be incomplete and may require equitable resolution. So the answer should not be either unrestricted coastal states enforcement or an absolute freedom of navigation. So in my view, the better bridge is due regard. Foreign vessels exercising freedom of navigation in EEZ must have due regard to the rights and obligations and duties of the coast states and to the interest of the other states, other user states. In the cable context, those interests may include the state of cable owner, the state connected to cable, the state dependent on digital infrastructure. Due regard is an obligation of conduct, not a result, but it can require consultation, cooperation, avoidance of unreasonable interference, preserving evidence and prompt communication after the incident. For China and Europe, this is both a point of divergence and a possible point of cooperation. Europe is understandably concerned with critical infrastructure protection. China is likely to be cautious about creeping coastal states' jurisdiction ironically. A common agenda could focus on Article 113 implementation, flag state investigation duties, consent-based boarding, evidence sharing, notification mechanisms, and dispute settlement rather than simply expanding coastal states' enforcement power. So do I still have time? Maybe I stop here. I also want to.
Okay, sorry. I think Xinjun is slightly offline, but yeah, I think Xinjun said it very well about some case studies on recent, uncertainties over international law of the sea, Straits of Hormuz, and also the subsea cables. And those points are very interesting. Now we move to Dr. Volker Reuben. So you have the floor to address the previous questions. Thank you.
Thank you very much, Yang Li, and also to the ISIS for this fantastic seminar. Very interesting. Yeah, I can be in a way brief, because I do agree with what has been said, in particular by my dear friend who just spoke. I think there's a couple of points that I just want to reinforce. The first is about the customary status of transit or innocent passage. It is indeed a question of customary international law rather than a treaty law, because in this case, neither Iran nor the US actually are bound by the convention as treaty law, but obviously they have to comply with customary international law. Now, indeed, as has just been said, the situation with these kind of straits is actually very difficult under international law, simply because most of these, there are very few direct equivalent situations. The big choke points, if you want to, of waterways that connect the globe and maritime trade are all subject to very different legal regimes. So, for instance, the Suez Canal clearly is not. It is a matter of it's an internal waterway, so it's not subject to all of this. The Dardanelles have been mentioned as subject to a specific institutional regime. Strait of Malacca is another example. And then the oldest possible example we have is really the Great Belt in Denmark. And that was subject to a toll regime for a very long time until Denmark effectively lifted it unilaterally. So it's actually very difficult to construct from these very few cases and the specific historical context any general rule of customary international law. So I think the solution really must be, as has just been said, to develop a specific institutional regime which balances the different interests at stake and may actually be inspired by the Montreux Convention on the Dardanelles. So that's where I would be. Where I think is the peaceful solution, and that's something that clearly requires a lot of diplomatic acumen and commitment from the key players towards international law. And I think that's something that particularly China and the EU share, and that's something they probably can actually, if they want to, agree on a negotiating strategy. The second point is indeed, and I also indeed want to mention the Corfu Channel case. That is the benchmark. I think that's true. And in addition to what has just been said, the Corfu Channel case is also very important because it does indeed impose an obligation on the coastal state not to let its territory be used in a way that harms human life, either at sea or any other way. So that is the basis of the due diligence obligation that we now see very much developed by ITLOS in its advisory opinion. So that's something that is important to highlight as well. I think the other case, what is really important as well, this has been indicated just now, is to look at the cases, particularly of ITLOS, in terms of how some of these uncertainties in the law of the sea can be remedied. And what I want to highlight is in particular the tendency of the International Tribunal to resort to a comparative law methodology. So whenever it's confronted, for instance, with respect to the exclusive economic zone and uncertainties as to the rights of coastal states, then it does occasionally, and I think methodologically correctly, resort to a comparative analysis. So what do coastal states do in such instances, and what do they actually, what can we derive for the interpretation of the conventional regime? I think that's something that is to be highlighted. So we need to observe very clearly what particularly what coastal states are actually putting on the law books in terms of their treatment of new developments. In the case of the ITLOS developed this in regard to bunkering in the exclusive economic zone. But this is a methodological precedent that we need to, I think, resort to. I do also agree with what had just been said in terms of certain subsea developments. The communication cables have just been mentioned in terms of the uncertainty regime, but more probably practically, or just as practically important, are actually the undersea electricity cables that are now being used increasingly by states to connect offshore wind energy to the main grid, and also between exclusive economic zones or territorial seas. And it has just been, as it's just been explained, the law there is not clear, but it should also be filled by interpretation of the existing rules, and due regard may actually be an important way of resolving this. I think another case that will rise in terms of the importance of it is the treatment of what's called the shadow fleet, sanctioned tankers that present a certain risk in terms of environmental protection and other things. And I think that's the question of how to deal with these. It's also a matter of cooperation. I think that's very important. And the cooperation among as many states as possible, not just a few, and that's really in order to secure a broad legitimacy for the treatment of these sanctioned vessels. Currently, the only legal basis is really that there is uncertainty as to the flag of those tankers, and that allows the boarding of it, and then the bringing it to anchorage. But that's, I think, a bit is open to challenge. Let me put it this way, and it would be good that the EU and China think about how to address this. It's again develop an institutional regime, maybe even through the Security Council. So that's something that is interesting. And finally, I wanted to say that, as has also been said before, I think the challenges that the law of the sea is confronted with are quite impressive and quite pressing. And I think particularly the International Tribunal for the Law of the Sea, through its advisory jurisdiction, has shown the ability to keep the convention a living instrument. It has shown this very powerfully in regard to climate change. Nobody foresaw climate change as a problem of oceans governance in the 1970s, but it now is, and there is a robust legal regime being developed by the ITLOS, more or less by interpretation and quite methodologically correct interpretation of the existing law. And I think that's an encouraging sign. And I think I'll leave it at that. Thank you.
Thank you, Walker. So we have had the first round of the panelist presentations. Now, before I open the floor for Q&A from the audience, I think I might have 3 questions for each of the speakers, just following what you said. Actually, the discussion is very interesting and very wide-ranging. So we covered a lot of issues that we cannot exhaust the discussion today within today's webinar, but maybe I have some questions that in my mind that I will seek your answers. One is a very simple question: does the under the current circumstances, does the transit passage through straits used for international navigation has or has not become a customary international rule? So maybe each of the speakers could give a very clear answer to that, so that we can have a clear picture. This is the first question. And the second question is I think most of the speakers talk about a special regime or special arrangement to manage the Straits of Hormuz or other international choke points. The question is that, if we want to make certain special arrangements, so we have to start from the basic legal norms. but the final arrangement should be something not very identical. I mean, there should be some practical or pragmatic solutions to accommodate this kind of divergent interests of different parties. So what is the distance between these basic legal norms and the final pragmatic solutions? So do you have any ideas or thinkings on that? So this is the second question. And the third question is that, I think most of the speakers mentioned about the comparative studies, between coastal states, and also the Baltic states, their dealings with the submarine cable security, and also I think Eva mentioned about South China Sea, the China Sea, the sea areas adjacent to China. And also, I think there's some common concern here that, the security concern. I think China is opposing the, military intervention in those sea areas because out of the national security concern. And also there's security concern from the European coastal states, like bordering Baltic Sea or other, like Arctic. So how do you compare these two positions, and are there any, more divergent practices or more common grounds between Europe and China? So these are the three questions. So maybe I can, maybe in the reverse order, maybe start with Volker and then Xinjun and then Eva.
Yeah, thank you very much. So in terms of the customary law status of this transit regime, I think in agreement with what has been said also by Xinjun, I'm not sure it is customary international law, simply because if you're methodologically precise, you need consistent state practice, and there is just very little state practice because of the, as I mentioned, the specific regimes or specific situations of all these very few choke points. In particular, as I mentioned, the closest example of the, I think, of the Great Belt in Denmark, that toll regime was lifted unilaterally by Denmark, and I'm not sure that is actually directly transferable. And the Dardanelles and the Montreal Treaty really are a special regime. And I do agree with what has been said. What is customary international law is the baseline, innocent passage, and the rules of the Corfu Channel in terms of how a coastal state may use its territory or may actually not use its territory, or should control what is going on in terms of security risk to the passage of ships. So I think the clear answer to your question is, it's a differentiated answer. Certain elements of how you can, as a coastal state, or what you must do in terms of ships transiting, are customary international law. Others are not, I think, and therefore that's I think the answer to this. So that makes it all the more important to create a clear shared understanding, as you also said. And I think what you're seeing in the Strait of Hormuz is that it's an emerging ad hoc arrangement between some of the key players. Some of this we are seeing, and some of this we are not seeing, but certainly these are really ad hoc arrangements, and on that basis, I think that is a pathway forward to this situation. I think in terms of the second question, you also I think absolutely agree. I think there are shared concerns, particularly between in regard to security, and in regard to the waters, both internal. Both the territorial and the exclusive economic zones. And in regard to and that's a common, as I do agree with your question, or the tenor of your question. That's the tenor of some of these situations we've been discussing, from the shadow fleet to the subsea cables to electricity cables. All of these ultimately boil down to a large extent to security concerns, and I think the comparative law element is very important to instill an element of legal certainty. So I think that's probably something that we can also discuss on a very rational basis between the different, particularly between China and the US and the EU, in terms of how they're developing their legal regimes and how they are doing this ideally in synchrony, because that would, I think, give a lot of a lot of impetus and a lot of legal weight to what is going on, and be in line with the spirit of the convention. Thank you.
Thank you, Volker. So now, Xinjun, you have the floor.
Yes, as I said in the presentation, I also put a question mark on whether or not the transit patch has turned to be a customary international law. This case is quite phenomenal. I think if we look at the North Sea continental shelf case, the court actually developed a methodology to look at the non-state parties' practice in identifying whether or not a treaty rule, a treaty provision, the rule contained the treaty provision has been developed by the subsequent practice of non-parties to be the customary international law, because the party states practice may simply means that they have the contract obligation to fulfill, and nothing about the jurist's opinion of which one required by the construction of customary international law. So here, the UNCLOS, of course, we can look at the practice of the United States. United States always have a very strong position that transit passage has been part of customary international, but not the others, especially Iran. So the better way is to just like I suggest that put Strait of Hormuz into a sui generis regime, and therefore we will kill all the problems, and then probably the U.S. would be right that the transit passage has become a part of customary international law. And the third and three, I think that I can combine the security concern. That is very important. I think in the past and in recent, instance, for example, happened in 2001 between the U.S. spy plane EP3. There is a collision EP3 and PLA Navy flight over the I think 100 kilometers, close to the Chinese seashore. And so there always been somehow a security concern from the coastal states. I don't know if it's sufficient, although I mentioned the due regard obligation, but whether or not due regard will settle all the problem, I'm not sure, especially when you look at the rapid development of technology. The missiles and the unmanned underwater vehicles, all these potential security threats to the coastal states never imagined by the drafters at the time when the UNCLOS was concluded. So don't know. A general idea is that the maritime issues are not exclusively determined by the UNCLOS. We still have customary international law here. So it's a bit complicated, but still I think sometimes we need to think about whether or not a possibility a parallel developed alongside a parallel development of customary international alongside UNCLOS. For example, the air defense identification zone, that is something, also mostly, but sometimes the states may also establish identification zone in their land territory, maybe, or somewhere at their land, but mostly the identification zone has been, designed to certain marine areas, and then you can see there's nothing, in that UNCLOS can do with the airspace over the this certain maritime area. So it could also be a parallel development of international law to take into consideration of security concern. In the meantime, I think due regard also play a very important role. I think the case law, as Professor Rubin has mentioned, the recent case law has relatively, just stable in indicating all these criteria in applying the due regard obligations. For example, Judge Park's famous formula on the location, timing, and nature of the activities, that all the items have to be taken into consideration when we making a judgment on whether or not the due regard obligation has been fulfilled. I think I stop here.
Okay, thank you, Xinjun. Now, we move to Eva. So you have the floor, please.
Thank you, Yang Li. I think I'll just take the last question then, because all the legal ones have been answered by the lawyers. On the comparative approach and the South China Sea, because you pressed me on that one. Clearly, well, probably the main reason, if not the one main reason, for the West or Europe and the world kind of viewing China's approach to maritime affairs with suspicion is precisely because it's been observing and how it reacts to the developments in its vicinity in the South China Sea and within the First Island chain. Be it the kind of unilateral interpretations of UNCLOS, but also some of the coercive actions against, fishing fleets and use of coast guards, etc., etc. I mean, we all know the problematic, but clearly, I mean, that case has been used as an example of for criticisms or perhaps some suspicions over China's intentions or ambitions in the region. Now, I fully agree that, I mean, in this particular case, the geopolitical rivalry layer is clearly complicating everything because, it's action reaction. The moment that foreign fleets and especially the United States would go through the region in a show of freedom to demonstrate the attachment to freedom of navigation, it will be interpreted in a certain way by China. Here we're getting into a vicious cycle. And of course, it applies to also Europeans who are inevitably United States allies and therefore are kind of associated to this movement and considered as being part of this containment strategy, which it is not. It should be read on kind of case-by-case basis, and it really should be, at least on the side of Europeans, interpreted as a demonstration of freedom of navigation. Because as Europeans have said many times, the South China Sea and all those waters that carry European trade are also in our interest as user states. So these are things that will be difficult to reconcile. They can only be managed. And I think it's absolutely crucial to distinguish about the type of activities that we are exerting. Been mentioning about sabotage, cutting cables, shadow fleets, or any type of belligerent behavior that we're seeing in the Baltics, for instance, is not exactly the same as the Dutch frigate kind of flying through the Taiwan Strait or anything else, and hence the importance of trying to, as I said, securitize the activity, but not the zone, not the maritime space. Would be a way to go about it. And of course, try to exercise some restraint on all sides is the basis, but often easier to say than to do, because these are not issues that are just pertaining to maritime, but unfortunately, these are things that are highly dependent on the developments in the capitals and on land.
Okay, thank you, Eva. So thank you for answering my questions. But anyway, I feel that this question is still very open for discussion, discussion. But now I will give the chances for the Q&A from the audience. I think right now we have already had 3 questions from the floor. I will read them. I think the first question is from Mr. Kate Gazert, and the question is intended for Dr. Pejsova. So you mentioned rightly that the huge economic impact of the Hormuz crisis goes much further than touching China and the European Union. Are you optimistic that a solution will happen in some months and not in some years? So maybe Dr. Pejsova could answer this question first, and then I'll go on with other 2 questions.
Well, I'm an optimist, so I think this is such an urgent topic. We in Europe we always use the word wake-up call, like, so this is yet another wake-up call. It's been very much discussed. Of course, everything depends on the quality of the agreement that will be on the solidity of the ceasefire, right? So that's the first most important starting point. But from the debate that I've seen here in Paris, in London, that has been going on since the outbreak of the war with Iran, there has always been a great willingness and lots of planning on how a type of a defensive naval presence, European-led or international-led European naval presence in the region would look like. There is a consensus among the, let's say, coalition of the willing that goes beyond also European countries, be it the UK-led initiative or the French one. There is precedence as well, be the European Maritime Security Initiative in the Strait of Hormuz since 2020. So there are working mechanisms that are being talked about in a very active track, including with the regional countries. We have also seen it being debated in the G7 summit. So I'm quite confident that on the practical level, the Europeans can actually pull it through. But of course, the biggest condition and the primary one is to make sure that there is peace.
Thank you, Eva. Now I go to the second question. I think that question is from Mr. Pop Wolfgang. And the question is, some scholars interpret the volumetric understanding of sovereignty in China's 15th five-year plan, for example, for deep sea and even its interest in Arctic, as extraterritorial expansion. So could you agree? Mr. Wolfgang does not indicate which the question is targeted to whom, but I think maybe I will give the floor to Dr. Zhang Xinjun to answer this question because this is about China.
Okay. I think the answer is clear, no. There's not, it is not our, we don't have such a title or sovereign rights over the things in Arctic or the other places in the deep sea. We may have some freedom. We may have some quiet rights under the convention or something else, but no, it's not. It's not something similar to the sovereign rights. Yes, that's my question, my answer.
Okay, thank you for your very brief answer. Are there any other speakers who want to add to that? No, then I will proceed to the third question. That question is from Alec Caruana. The question is, both Professors Zhang Xinjun and Royben mentioned the potential development of a bespoke legal mechanism for the Strait of Hormuz, using the Montreux Convention as an analogy with EU and China input. Could you elaborate on what role they could potentially play, for example, technical expertise, negotiation facilitation, and will their interests or legal interpretations align and diverge? So maybe Royben first and then Xinjun.
And that's a fascinating question for a lawyer because it's actually about negotiation. I think we shouldn't forget that the ultimate obligation here in play is that of peaceful settlement of disputes under the UN Charter. I think that's the legal basis on which the EU and anyone else actually should proceed on this. I think it's important to have the right full analysis of available precedent and potential examples to put to parties and move forward. It's ultimately a matter of negotiation skill, and I think and trust, to be honest, about the good faith intentions of everyone who is interested in this. And if it can be pulled off, it will be a wonderful success for the further development of the Law of the Sea Convention. Thank you.
Thank you. Then, Xinjun, you have the floor.
Yes, I very much agree with Professor Rubin. I think it's very hard for lawyers to imagine what kind of institution would be built. It largely involves a political process in doing things like that. Maybe we can suggest some bottom lines, but never. Some of the factors I think need to be taken into consideration is, for example, the safety of passage, through the strait, and the legitimate security concerns of of Iran's security, things like that. Maybe we can also refer to Gulf Channel case, indicating there's something. I just say that we may use a knowledge of the Turkish Strait, but not copy them, because each and every these special, the strategic straits, they have their own merits, right? You have to think carefully about how to design the institution in accordance with each and every cases. So basically, there maybe pop up some general considerations, but never. I don't think that we can do for now a much detailed homework how to design the institution. Yes, thank you.
Thank you, Xinjun. So now we have the fourth question from the audience. It's from Daniel Banatz. What are the legal and diplomatic prospects of EU-China cooperation on submarine cables, considering the increasing secretization in this field? Can the two sides pivot toward confidence-building measures, or will they just pursue their self-sufficiency drive? And so this question, I think, could be answered by all the speakers, from both Chinese side and European side. So maybe I start with Eva, and then Xinjun and Volker.
Yeah, that's a tricky question, because, as you know, in the context of the Baltic Seas, there has been some tensions between Europeans and the Chinese flagged vessels that have been actually one of the persecutors. So in a way, China is both a stakeholder in this debate and a suspect. So there is quite a bit of I would say reluctance at the beginning, precisely also because of these incidents that would need to be clarified. But if I try to be constructive and look more, I guess, on the diplomatic side of things, I would imagine that such cooperation could take place more on the IMO level, on the kind of new regime setting, or discussing those possibilities for future governance. But in practical ways, the debates in Brussels are not necessarily seeing, because of the incidents in the Baltics, China in a very positive eye when it comes to undersea infrastructure. And as you know, that there is a new legislation in the EU also on the critical undersea infrastructure, on the critical infrastructure in general. So we're trying to be a little bit more, I'd say protective, but very careful in these matters. So we'll see, probably in some technical areas and on the legal side, yes, but one day.
Okay, thank you. Now, Xinjun, you have the floor.
I think there are 2 points. The first, I think, is maybe the flag states' good faith implementation of the Article 113 obligation to investigate, to fulfill the responsibility as the flag state and investigate and prosecute any crimes that made by these the shipmasters in the foreign EEZ. And the case I mentioned, the new Paula, that one, I think the masters has been taking the criminal proceedings in Hong Kong. I just did a little investigation on that case. I think the last time, the last appearance of the defendant in that case was February this year, but case is still pending. Of course, that shipmaster plead no guilty in that case. I don't know how the Hong Kong prosecutor will take care of this case. I will keep an eye on that. And the second point, I think, is also very important, cooperation between flag state and coastal states in on-site investigation. I think it has been, it has happened in several cases. To remember exactly which one, the Chinese authority actually invite one of the Baltic coast states to jointly do the investigation on site. Such kind of cooperation, I think, should be encouraged. Yes.
Okay, thank you, Xinjun. Now, Volker, you have the floor.
Yeah, I do agree. And I think just to add to this kind of judicial cooperation may actually take place as the frameworks outside of the Law of the Sea Convention, but that exists. And I think it's an important resource to use. I also think that generally, if you look at the thing that's been mentioned before, the case law of ITLOS, it does contain important pointers about how to resolve these issues. And fundamentally, it's always advantageous to have legal certainty. So if there is a coordinated development of coastal state legislation, that is to be encouraged, and I would do so.
Thank you. So now we have another question from Zhang Shiao, I think from China. Thank you to the three professors for your presentations, and I would like to pose a question. If the Strait of Hormuz were to inevitably follow a Montreux Convention-style regime, from a legal perspective, what mechanisms or methodologies do you believe should be incorporated into such an agreement to ensure procedural justice? Additionally, which countries ought to be involved in this process? Thank you. So I think this is a very specific question. So maybe start from Volker and then Xinjun and then Eva.
Yeah, I think the interesting bit is really to look at the fact that the Montreux Convention has actually worked very well. It's an old instrument, and it solved at the time a political flashpoint. And we shouldn't forget that it was its mission, and it has actually worked quite well. It does give clear powers, but also limits to the coastal state. I think that's important. And as has also been said earlier, we need to recognize the various interests at stake here. So it needs to be a bespoke development. I think again, coming back to some including in particular the toll question, I think there may be lessons to be learned here. And these elements can all be included in a package deal. Who is to be involved? Well, I think to a certain extent everyone, because as much as possible, because the Strait of Hormuz is so critical to the world economy, and that may dictate the proper venue for this kind of negotiations. We may actually need to be looking at the UN for that purpose, but that's obviously speculation.
Okay, thank you, Xinjun.
Oh, also the speculations. I think most recently the Security Council tried to adopt a resolution on this Hormuz Strait case, but that had been vetoed by Russia and China or something like that, or abstained. I don't remember the details. The reason is that the resolution is one-sided, did not address the U.S. U.S. military, that part of that aspect of the incident. Anyway, so I think maybe the P5 is very important because it is not only the strait is a strategic strait. It's not a matter of purely Iran's security, but it's also the security of the sea lanes, energy, or everything, and probably also involves Oman. I think is a very important one because if you look at the strait, it's a part of. I think the Iran and Oman they divided that part of the strait by using the median line. Maybe I'm wrong, but yeah, my something like that. So you still have the Omans, that part of sea lane, but whether or not it's suitable for navigation is another problem. I did not invest much on that. So regional state and P5, I think they are important players. Yes.
Okay, thank you. So then, Eva?
I think that legal question has been pretty much well answered by the two previous speakers, but I saw that there was another one on IUU fishing that popped up in the meanwhile. So I'm happy to take the IUU fishing instead, if that's okay.
Okay, no problem. Yeah, I think that question is from Daniel Balas about
Yes.
IUU fishing.
Yes.
Yeah, the question is maybe just briefly repeat it. Action on IUU fishing is often brought up in the context of EU-China maritime relations. Is this an area where the two sides can cooperate, and what would such cooperation entail? Or is this an area of friction between Brussels and Beijing?
Yeah, so it's a little bit similar, like with the undersea cables. It's both. Because of course, I mean, we've always been talking about environmental cooperation and fisheries as the kind of lowest hanging fruit for EU-China cooperation. Because we all agree we need to save the world and the planet and the fish. But of course, China has been one of the culprits. China is the largest fishing country in the world. It has been, featuring some of those large factory ships, which are just quite unsustainable fishing practice. It has had record of IUU fishing in Indonesia's waters and around the region, etc. And of course, we have to also, and we are working actively with our Southeast Asian partners on IUU fishing as well. So it's both. And this is one of the problems in general, I guess, in trying to find common grounds in EU-China relations and cooperation, is that there are plenty of avenues. We need each other, but there are a number of precedents that are just making things politically a little bit more complicated. I think the possible meeting space here would be together to try to improve the kind of more multilateral settings. So the regional fisheries maritime organization. So trying to get more China voice and more China support for those institutional approaches that we both trust and that can actually make a real difference in on the ground, being the marine protected areas, RFMOs, within the FAO fisheries committees, etc. So I think that's definitely something that would be very, very appreciated.
Thank you, Eva. Are there any other speakers who want to speak on this subject? IUU fishing? Okay, no.
Professor
Yes,
Chan?
maybe. Yes,
Okay, yeah, I think
yeah.
yeah.
Thank you, Eva, for elaboration. I think China's position is getting more and more positive regarding the measures taken against IUU fishing. I think maybe most recently, China became the party to the what is a port state control measures, the convention on port state control measures taken against the IUU. So this is, in my view, a positive gesture from the Chinese side. But again, as you may be right, China has maybe the one of the biggest the far distance fishing fleets. So we may have from time to time the problems on the issue of IUU fission. I think illegal is okay. I mean, maybe there are controversies on what kind of activities can be regarded as IUU fission. Illegal fission, I think that is relatively clear, but the other two U's involves quite a lot of interpretation, and sometimes I think some communications in between the stakeholders, in between China and EU, I think is important. Maybe with the help of the organization Roma, what is
FAO.
I feel yes, maybe.
So I thought, well, the shark finning ban was a nice gesture.
Yeah, that is also a giant step, yes, taken.
Thank you. Thank you for the above speakers. And then I think I can proceed to maybe the final question from the audience. And I think in answering this question, maybe the speakers could also wrap up to briefly summarize their takeaways, so that I will give maybe 2 minutes for each speaker to wrap up, and also in answering to this question. But before that, maybe I will add one of questions of my own. I will first read the question from Alec. If there is a possibility to shift norms more comprehensively to securitizing or penalizing conduct rather than geographical location, what legal fora or processes pose the best opportunity for this? So this is the question, I think, for the three speakers. And my question is that just now Xinjun talked about the principle of due regard. And also, I think this is one of the keywords that could address a lot of new challenges brought about by this rising securitization toward the legal regime over the ocean governance. But how to understand this due regard? And sometimes I think a reasonable regard is also used somewhere else in the Law of the Sea Convention. So maybe the key is to materialize or implement this due regard principle or reasonable regard principle. So what are the views from the speakers regarding this? So maybe I will start with Eva, and then Xinjun, and then Volker to answer these two questions, and also your brief takeaway from the meeting. Thank you.
No, I'm afraid I will be very, very brief, because what I'm looking forward and what I'm enjoying actually almost most in this conversation is to listen to the lawyers, because that's, as opposed to our kind of, people who talk about security and geopolitics all the time, the lawyers seem to actually have very concrete answers and often very, very constructive. So I'm really enjoying it and look forward to hearing from them. But I mean, my humble take is that, when we talk about due or reasonable, I mean, all this is very vague. And I think, frankly, regardless of the legal interpretation, which can be, I guess, numerous, what is considered, reasonable or due, it really depends on the goodwill. I mean, everything really ultimately boils down on what you want to do about it. And if countries ultimately, regardless of the legal dimension, want to break the law, well, they still can, I suppose, right? And there is very little that so far the international community is going to be doing about it, unfortunately. And that's probably one of the biggest problems. So it's all about our own and country's own capacity to kind of exercise restraint, goodwill, show goodwill, and try to work on ourselves. And to see and to judge for themselves what is the cost they are willing to kind of sacrifice for the sake of national security. What is national security in a especially when we talk about maritime, in a world where everything is pretty much interconnected? What is the balance that we're kind of willing to give to things, right? So on those very wise and very, sorry, sick words, I will probably stop here. But I think this is a more ideological debate that we're having here. It's not just about law and order, which is a nice thing, but if you want, you can break it. But it's really about what sort of international player you want to be. And in that sense, I believe that China and Europe can find a way precisely to show that we can actually make the world a better place. And I'll stop here.
Yeah, thank you. I think the law is about providing certainty and predictability, but sometimes lawyers just add confusion to that. But anyway, thank you for your kind words to lawyers. I think so, and I think what you said about balance is another key word, to push forward the international rules making. So now, Xinjun, you have the floor.
Okay, thank you. To Alex's question, I don't quite very much take this one, but it seems that the law of the sea has been built up, in particular in accordance with geographical locations. So different marine zones, there will be different allocation of powers in between the United States and coastal states, and sometimes the authority of some international bureaucrats, for example, the International Deep Sea Authority. So the power has been allocated in accordance with different geographical locations, and that is the law of the sea regime. So far, it works. I think is relatively okay. So if we want to have something new, I think that we need to have a very compelling reason to do some modification of this UNCLOS regime. And then to the question of due regard, yes, it's very complicated. Due regard is not about allocation of power. The power allocation is clear, and you have the power to do something. For example, the coastal states have the power to regulate fisheries and regulate in the Saiga case, regulate the Saiga and the Virginia case, the bunker, right? The bunker to the fishes. It was also taken as the thing falling into the coastal state's power jurisdiction. But still, when you exercise this power, you need to follow the rules. Due regard is one of the rules, and the other things, I think Professor Ruben mentions the humanitarian considerations, all these things. But still difficult. I think the court and tribunals again and again stated that this obligation of conduct rather than an obligation. So it is, in Judge Park's words, there is no hard and fast rule in clarifying or on the contents of this due regard obligation. It has to be taken into consideration in each and every case. It's a case-by-case thing. So that is my answer. And my wrap-up is that I think China and the EU, and that it's unrealistic that we agree on every legal questions posed in this seminar. But I think that we still have some overlapping interests. For example, open sea lanes, stable energy transport, secure digital infrastructure, sustainable biodiversity governance, etc. So we're looking forward to this cooperation while we keep the differences wheels on the other legal questions. Communications, I think, is very important. I think this seminar will contribute, at least among the scholars, I think, right? The communications between China and the EU on the law of the sea issues. Thank you.
Okay, thank you, Xinjun, for your very encouraging words. And then, so Volk, you have the final say on this.
I wish no conclusive summary from me. I think the previous speaker just put it really well, how I also see the function of the law of the sea. And it has, I think, delivered on this. It is really a framework for cooperation based on legal certainty to the extent that can be provided. It's important to realize that, I think that's what I said at the beginning as well. The convention has been able to adapt to new challenges and develop new rules, and we've seen this very, very powerfully in the area of climate change in particular. So I think it can do so on the basis of the shared values and the interests that are enshrined in it. It is a framework convention in some sense, or constitution of the oceans, however you want to call that. But it means that the states parties have subscribed to certain fundamental principles and to basically the idea of resolving their disputes peacefully and in a cooperative manner. And I think we will see this year as well.
Okay, thank you. Thank you, Volker. Thank you for all the speakers. And then now maybe it's not, it's not the time for conclusion, because this is only a start. I think the ICES is expecting to hold more events like this to discuss all the issues. They're very interesting, and there are plenty of room for further debate. So that today we covered a lot of issues, ranging from theoretical ones to very pragmatic solutions or proposals. So that I think I learned a lot myself from that. So thank you for all the speakers, and thank you for all the participants who stay with us all the time. And so looking forward to see you again, and for further interesting debate. Okay, thank you all, and have a very nice weekend.